Hello everybody, my name is Kamoha Faith and welcome to Attorney's Corner. In today's episode, we will be discussing the processes of getting to and administering a road accident fund trust as well as a medical negligence trust. For the purposes of this video, I will be referring to the road accident fund trust as a court order trust. Now, you got into an accident, a motor vehicle accident, and you believe that you have a valid claim against the road accident fund, and you go to attorneys and they confirm that you do have a valid claim. They submit the paperwork to the RAF officers and then they start the process from there. Now, during this process, you will be required to see medical experts, medical doctors, and then those medical doctors, in their professional opinion, in their report, they state that there should be a trust or a creator bonus for the protection of the funds that you will be receiving from the road accident fund. Now, usually this is done, or they would recommend that there should be a trust created due to the head injury, if you due to the injuries that you sustained, more specifically if you had a very severe head injury. And then also they look at your outside circumstances and your influences, and if they believe that there are people, vultures, that would come and then influence you to spend the money in a reckless manner, to spend the money in a manner that it was not intended to be spent, they would state that there should be a trust created. Now, you go to your trial or you settle with the road accident fund, and then the court or the judge states that there must be a creation of the trust. That the judge grants the order, and now what happens is that if there is an independent trust company that is going to be administering your trust, that the attorneys now give the relevant documents to the trust company, and they now need to register the trust at the master of the high court. The master, you lodge, the trustees or the trust company lodges those documents at the master of the high court. They receive the letter of authority. Usually it is in the name of the trust, which is usually the name of the beneficiary, like maybe let's say the Kamoha Faith Trust, because I'm the beneficiary that is going to be receiving. Well, the trust is going to be in my name. I'm going to be the beneficiary of that trust, so it would usually be in my name. And then they receive the letter of authority, the trustees, and then they open a bank account in the name of the trust, and then the attorneys would now pay over the funds that they received from the road accident fund to the trust account that is created in your name as the beneficiary of the trust. Now, after the trustees receive the funds in the trust, they should now go ahead and arrange for a meeting that is in person between them and the beneficiary. And in that meeting, it is very important for them to explain to the beneficiary what a trust is and how a trust works. Because in Black South Africa, we do not know. We have no inkling of how a trust works. Some of us don't even know what a trust is. Some of us didn't even know that you can have a trust created from funds received from the road accident fund. Now, the trustees should explain all of that to you, what a trust is and how a trust works. And essentially what a trust is a vehicle for protection of assets, where trustees have control over the assets and they manage those assets for your benefit. Now, in most of these meetings, when the beneficiary comes, let's just say the beneficiary comes from deep rural Limpopo, or from KZN, deep rural KZN, or from the township, and they do not really understand English, it is very important, or they do understand English, but I still feel like it is very important just to have a translator in the room to explain the process of a trust and how it works, because really there's so much legal jargon into this that we just, because we are used to it as legal professionals, and we just speak and we just explain without thinking that maybe this person doesn't really understand. Because when somebody doesn't really understand something, I've seen that they will just sit there and nod and say, yes, I do understand. And then uh, after time has passed, and you try and they come and they request something, and then you state that, but this was explained to you in the meeting, and then you realize that maybe they didn't really understand what I was saying. So then it creates issues in future. So if you can just have a translator that can speak to them in their language, just to make the understanding of how trust works and what a trust is just a bit simpler for them, I that is for me, that is gold for me. So in this meeting, you just explain that a trust is a vehicle. As trustees, we explain the trust is just a vehicle for the protection of your assets. Trustees will manage the funds on your behalf, and the control of the management and the administration of the trust, or the assets that you have in the trust, will be with the trustees of the trust. Now, I believe another important thing that the trustees must explain to the beneficiary of the trust in that first meeting is the costs that are involved with administering the trust on their behalf. Now, there's administration costs, there is surety cost, and then there's the trust must be audited. There's going to be auditor cost and then accountant costs as well. So those trusts you must explain. If there is a section 17 undertaking for that particular trust from the road accident fund, you must just explain to them that just because they have a trust doesn't mean that the trust should cost them money. We can use this section 17 undertaking, and then we can claim all those administrative costs from the road accident fund, the surety cost, the medical, yes, I forgot, yes, the medical cost as well. If what the section 17 is for is that it's for when you have a medical injury, or you have medical problems that are related to the accident, then you can go visit a doctor, a medical practitioner, and then the road accident fund should pay for those costs. That is what the section 17 undertaking mainly is for, but it is also for the administration of the administration cost of the trust. So now we explain that to the beneficiary, and then we get into the gist of the meeting, and then we get to learn a little bit more about the beneficiary and their circumstances and their surroundings and their socio-economic, especially the socio-economic circumstances. So now, when we come to that part of the meeting, a problem that I usually face, and a problem that I don't want to say angers me, but disappoints me, is the fact that before the trust is created, or before it even gets to the trustees, the attorneys, while going forth with the case, they have their own consultations with their clients now, and then within those consultations, there's always an expectation that is created of what the trust can do for them, and usually this information that they give to now beneficiaries when the trust is registered is incorrect, because there are certain things that the trustees, they have discretion to do, but the whole point of being a trustee on a trust is the fact that you should administer and you should take care of those assets better than you would your own assets. So now, as a trustee, as trustee of a trust, you can't just say yes to every request, and you now this in that information is given by the attorneys to their clients, and be like, when the trust is created, you can ask for whatever you want, and the trustees will give to you everything that you want. And that trustees have discretion to make payments of certain things, but not everything. Everything cannot be given to a beneficiary, unfortunately, because some of these requests that trustees get are a little exorbitant. That's all I'm saying, that there is a disappointment that just comes from that side, from the attorney side, that they create this expectation that trustees and trust companies just can't fulfill. Now we get into that part of the first meeting between the trustees and the beneficiary, and then you ask them about their livelihood, if they have any children, how many they have, where they live, their life circumstances, their employment, and stuff like that. And then after you've heard those things, what you are going to tell them is not what they're going to want to hear, unfortunately, because in those, what they will be telling you in those statements is that I have children, I have 3 children, they're all in school, and their school fees needs to be paid, and so on and so on and so on. And unfortunately, in most court order trust, it is in the trust deed, it is stated that this specific person is the sole beneficiary of that trust. So the trust cannot take care of anybody other than the sole beneficiary. Now, that's not what beneficiaries want to hear, but that's unfortunately the reality of it. Which also, this is why it disappoints me when it comes to attorneys and then the information that the attorneys give them, that they can ask for anything when the trust is created from the trustees, because that's not the reality. Now, usually the funds that you would get from the road accident fund would be for either the loss of income or medical expenses or general damages. Now, the funds for the funds that you get in the trust, I'm just going to quickly explain the funds for loss of income. Now, you are when the accident happened, you were a 26-year-old man, and you worked as an artisan, and you got 20,000 rand a month. Now, because the accident happened, your capacity to perform in work and still receive that 20,000 a month is now limited, and now you can perform as an artisan, but now you can only perform to a place where you can only earn 10,000 rand a month. Now, what the ref would do is that they would supplement the income that you have lost due to the accident, which would then be 10,000 rand, and then they believe and say, they would do their own calculations and maybe say that you would have worked from 26 maybe up until 50, and now because your capacity is limited, and your earning capacity is now limited to you earning 10,000 rand less, we would give you 10,000 rands from 26 up into, what did I say, 50, up into 50, and we will give you that in a lump sum. Now, that when it comes to those funds, that loss of earnings funds that are now being transferred over, that are being paid over to the trust, the trustees must think of them exactly in that manner, that it is to supplement the income that you would have received, but because your earning capacity was now limited to less than 10,000, that is how those loss of earnings should be paid out. They should be paying you that should be supplementing your income on a monthly basis, and they can't give you that amount in a lump sum, because that amount is meant to be spent, well, it's meant to be given monthly as to supplement the earnings that you would have received, but you now can't because your earning capacity was limited. And that is how I believe that the loss of income should be paid out to beneficiaries. But you could also earn general damages, and let's just say your total that you received from the road accident fund is 1,200,000. It includes general damages, but it also includes the loss of future earnings. I already explained how the loss of future earnings should be paid out, but then there's this general damages aspects. You had pain and suffering, and that money is supposed to console you and the pain and the suffering that you sustained. Now, you as trustees, you can't just pay out that general damages lump sum, because if the court wanted to do that, they would have done that. They would have paid it directly to the beneficiary instead of placing it in a trust. Now, because it is in the trust, that lump sum that you received of 1.2 million, the trustees, that is then when it gets into the trust, is called the trust capital. The trustees need to take those funds, they should invest those funds so that those funds receive interest, and then you can receive a portion of those interest monthly. What maybe the trustees would call it a monthly income. You would receive income monthly from the trust, from the interest it has earned from the investments, because the purpose of a trust is for the protection of the funds, which is number one, and then but then also that the funds that are in the trust, it should last you probably up and, let's just say a trust, it states that the vesting date of the trust is at the death of the beneficiary. Those funds, the trustees must manage those funds to last up until your date of death, if it states that. If they don't, they're not doing their job. That's what trustees should be doing. So now it becomes a very difficult situation when a beneficiary then comes with the request and says, but this is too little. This is not what I expected. This is not what my attorneys told me I would be receiving from the trust. And unfortunately, the reality is that the trustees must manage your funds better than they would their own assets. It's just the unfortunate part of it. So most requests are going to be declined by trustees from beneficiaries because they cannot say yes to everything. Now we have a beneficiary coming forward and saying, I live in the most terrible of conditions. I don't have a house. I don't have a car. Can the trust please buy me a house? Can the trust please buy me a car? And you only have 1.2 million in the trust, and the vesting date of the trust is your date of death, and the trust funds must last up until your date of death as the beneficiary. Those funds, 1.2 million, in reality sounds like a lot, but it is not. 1.2 million is not a lot. There's no way that the trust cannot afford to buy a house, and the trust cannot afford to buy a car. Because number one, you buy a house, there are costs that are included in the purchasing of a house. There's going to be maintenance that needs to be done on the house. That is another cost. There is going to be insurance that has to be paid on that house. Those are costs and expenses that would eat away from the capital of the trust, which means that if a trustee does do that, your funds would only last 2-3 years and not the duration of your life, which is what should happen, which is how you should manage those funds to last the duration of your life as a beneficiary. Also, when it comes to a car isn't really an asset. A car is a liability. Now, the trustees, they purchase a car in the name of the trust. The car needs to be serviced, the car needs to be maintained, the car needs to be insured. Again, expenses that would eat away from the capital of those trust funds, which is not what should be happening when Now, I understand that this type of situation would anger most beneficiaries because the expectation that they got before the trust was even registered is that they would be able to receive whatever they would like from the trust and it would just be given to them. But unfortunately, that is just not the reality of it. Now, as beneficiaries, you have a right to ask for documentation of the trust. You have a right to ask for investment statements. You have a right to ask for bank statements just to see how your funds are being managed. Um, and trustees usually do give those should you ask for them. So that is not really something that that you should be worried about. But then an issue that arises is that because of the lack of understanding, there are so many people who are beneficiaries of court order trust that now come and they don't understand, as I said, because of the lack of understanding, and they say, but the trustees are stealing my money because the trustees cannot be paying out everything or be saying yes to every request that they receive. Now the beneficiaries come and say, but the trustees are stealing my money. And that is, in most cases, that is not true. That is not true. But if you are a beneficiary and you have those bank statements, you have the investment statements, and you do see that something is off, you can, because you should have your letter of authority, the trustees should have provided you with your letter of authority. You can take your letter of authority as well as a copy of your surety, because again, the trustees should have provided you with that copy of the surety. You take that to the master and you can lay a claim at the master's office. um, I'm not sure if I explained what the surety is, but I'm going to quickly do so. So the surety is basically insurance for you as a beneficiary against the trustees, that states that should the trustees run away with your funds or should they do anything, just anything bad or anything that is illegal with your funds, you can report them at the master's office, and then the master's office will probably launch an investigation, and if there is anything wrong, they're going to probably remove the trustees, and those funds that they appropriated would be claimed back, misappropriated would be claimed back from the insurance company, which gave them the bond of security, the bond of undertaking, the security. Now, I believe I've discussed quite a lot when it comes to the Road Accident Fund Trust. Now, the tricky part comes in when there is a trust for a minor, either a court order trust or a medical negligence trust. The process of the medical negligence trust, it would work the same as the road accident fund trust, but the difference is it wouldn't be lodged with the road accident fund, it would go to the MEC. Now, the tricky part comes now when there are parents involved of these minor beneficiaries. And what I have seen that saddens my heart is that most of these parents are looking to fund their own lives with the funds that are meant to be for their children. Now, when it comes to the medical negligence trust, it is usually because there's some sort of, there is a child, the child is a cerebral palsy child, that they can't really do anything for themselves, so they are reliant upon maybe a caregiver or their parents just to excuse me, just to take care of them in their life. And then there's a trust that is created, and usually the funds from for medical negligence are much more than what you would receive from the road accident fund. So now what happens is there's a parent involved, and usually the parents would send requests for cars, for how I would understand I do understand uh, the request for a car and the request maybe for a house, because living with a CP child is not a very simple thing, and then they would probably do need the space for the child. And then when it comes to the car, most CP children frequent hospitals a lot more than a RAF child would, because they have those medical needs that need to be attended to. So they would frequent hospitals, and they have a lot of therapy that they need to be taken to. So that in that case, a car would come in handy, and a car would be an acceptable purchase to make. But also because the trust can also afford it, because the funds that do come into medical negligence trust are much larger than funds that you would receive from the road accident fund. So the problem comes with the requests that the parents make that are for their behalf and not on the behalf of the beneficiary, which is the child. So now these funds that are from that you receive in terms of a medical negligence case are mostly they are mostly for the medical needs of a child, because this child is going to have probably medical needs for the rest of their lives, and they're probably going to have to see doctors for the rest of their life and have that therapy for the rest of their lives. So that's why the funds are much larger. So now parents come saying we need a gas stove, and then a parent comes saying no, but I need a pavement outside, which is not to the benefit of the child. And then they come with other requests, and then the trustees say, but this is not to the benefit of the child, number one, and also this is something that probably the trust can't afford, if the trust can't afford it, number two. And then the parents get very angry at the trustees, and then the relationship between the trustees and the parent or guardians of the CP child is broken, and is broken indefinitely, because once money is involved, and you believe that you are entitled to that money, and somebody says no to you, that relationship is not going to be a smooth sailing relationship. It's something that is going to be rocky at every end. Now there are these type of parents, and then that do send in requests, and then trustees say no. And I feel like as Black parents who do have a CP child, we understand that it's very difficult to raise a disabled child. But the job of a trustee, as I've previously stated, is to manage funds or assets in the trust way better than they would manage their own funds or own assets. So now when a parent comes and they request certain things, we get emails and messages that states that this is my child's money, you are stealing my child's money, why won't you give me my child's money? It's because, ma'am, sir, we cannot just those funds do as we please. There are rules in place, there are processes in place. You need to understand that in most cases of I'm just going to use CP children. In most cases of CP children, when the case happened, they probably would have been a life expectancy of a child of, maybe let's just say the child is going to live up to 20. But we have seen that CP children live longer than 20. They can reach the age of 50, they can reach the age of 60. Now, those funds should be able to last up until the death of the beneficiary. Therefore, the funds must be managed in such a way that not every request can be approved by the trustees, because we need to look at when you get older as a beneficiary, you, especially as a medical or let's just say as a CPE beneficiary, as you get older, your medical needs are going to be more and more expensive. So the trust must have those funds to be able to cater for your medical needs. So parents, we understand as trustees that it is not easy for you as CP parents or as parents of disabled children, and then you are struggling knowing that there are funds available, but unfortunately the funds, yes, as much as there is funds available, it is not for the purposes which you deem that they should be used for. Those funds are for medical, especially medical needs, because CP children's medical needs are very expensive, very, very expensive. So I wanted to put that out there. But yeah, when it comes to the administration of trusts, especially when it comes to court order trust and medical negligence trust, um, I urge for the Black community to just understand that it is not the trust company trying to steal your funds when they say no to certain requests. It is really because they are doing what is best for you and for your benefit, and you might not see that those funds that they are giving you is going to change your life or is helping you in any way, but further down the line you are going to, you might not have anything, and the only funds that you have is the funds in the trust, and the only reason you have those funds in the trust and it's not depleted is because the trustees managed it so well on your behalf that you reach the age of 65, you are now retired, but you still have these funds, and these funds can still do something for you. So I just urge Black community, because we do see that most of these, well, I have seen that most of the road accident fund trust, the court order trust, and the medical negligence trust are predominantly in the Black community. So I just urge you just to understand that those funds are going to be they're going to be managed for your benefit, and unfortunately it is not going to be managed in the way that you want. I understand how. I also believe that that would anger me, knowing that I've received 3 million rand from RAF, and then I only get an income of 7,000 from the trust. I wouldn't understand that. Why? What is this for? Why am I only, I received 3 million rand from the road accident fund. Why is the trustees only giving me 7,000 rand? But then I also sit down and I try and explain to clients that, listen, the trust must, this trust, the vesting date is at the date of your death. This funds must last up until the date of your death. They must be managed up until the date of your death. The trust shouldn't deplete before then. You must also remember that you did have an injury. You got into an accident, you did have an injury, and um, you as a beneficiary in future, that injury might just affect you to a point where you're going to need medical assistance, and then you do have these funds from 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 the trust, because the trustees have managed it so well that those funds would then be available to cater to your medical needs when you are 50 or 60 or 70 or 80. We've seen that people are living a lot longer now. So we must just keep that in mind as beneficiaries of the trust, that the trustees are not stealing your money. They are not misappropriating the funds. They are not using the funds in any way, shape, or manner that they shouldn't be. If you receive just gonna say, if you receive annual statements from your trustees, if you receive statements when you request them from your trustees, if you have an annual meet, you should have an annual meeting with your trustees every year. Annual means every year. Every year, if you are a beneficiary of a trust, you should have a meeting with the trustees every year, unless you opt out of the meeting, or you believe that you don't really need to have a meeting. You understand. You can read your own bank statements, you can read your own investment statements when they send them to you. You understand those things. Then you don't need to have, but you should have a annual meeting with the trustees where they update you on the investments, where they update you and where you also just update them on how things have been for you. It's a relationship. This thing between the trustee and a beneficiary, it should be a relationship where trustees would account and explain the the background of what's happening within the administration process, and you should also come as a beneficiary and just with your experiences, so that we are all on the same page, especially when it comes to the understand, because there are so many misunderstandings that happen because one party said this, the other party didn't understand and interpreted it as something different, and that misunderstanding just makes it so it makes the relationship between trustees and beneficiaries much more difficult, and it causes clashes constantly. So yeah, if you are a beneficiary of a road accident fund trust, and if you are a beneficiary of a, a medical negligence trust, or you are a guardian of a beneficiary or parent of a beneficiary of either a road accident fund trust or medical negligence trust, just try to understand that there are certain things that are happening in the background, that there are certain rules that the trustees must adhere to, and there's a certain manner that funds must be managed and protected. And sometimes it is not going to be what you want, it is not going to be what you need, but it is the way that it should be, and unfortunately that is just how it is. So thank you very much for watching today's episode. I hope you enjoyed it. Please like, share, and subscribe, and I will see you next time.